sixth question, moving on in terms of topic within the company's law. Look at question 6. The dates are problematic. But, I don't know. Don't worry about the dates.
Sorry.
I'm calling Roger, please.
You finished it, haven't you?
Yeah, I've finished. I have finished it.
What do we think then? What's our advice to John?
Things looking forward is possibly unlikely. Got to discuss the whole corporate separate legal identity, piercing the veil, facade, all that sort of business.
Mm-hmm.
And then I think we concentrated for the potential section where there's cautious liability,
Mm-hmm.
with the chairman on case, where the parent company was liable for subsidiaries unsafe work practices.
Yeah.
However, that was very fact specific because that was where there was a trading company, had knowledgeable staff, geologists, I can't remember the exact facts.
Yeah, yeah.
There was another case where the parent company was not a trading company, but the Thompson and Leonard case.
Mm-hmm.
And in those circumstances, it's less likely that liability would attach to the parent.
Yeah.
Whether the parent is acting as an agent, you could have a look at. But I concluded on all of the facts that we have, which is not a lot. That's probably unlikely.
Are there any examples that you've come across where a corporate entity has been held to be acting as an agent on behalf of whatever the principal would be, depending on the facts, so another group company or personal shareholder?
There's only that DM on there that talks about single economic group or whatever it was, but I think that was then overturned by another decision.
It wasn't overturned, it was rejected, yeah. Yeah, so DHN looked at the single economic entity. In Adams and Cape, the House of Lords looked at the agency argument and said, well, it's possible, but those are issues of commercial law. In reality, the courts have never come to that conclusion. Yes. Any other issues as far as John is concerned? Anyone? Any other points that there is?
The subsidiary obviously is in insolvent liquidation, so good luck trying to get any compensation out of that.
Yeah, that's the starting point, isn't it?
Yeah, that's right.
Yeah. So that's the starting point, is to identify employer or glue sub is insolvent, and hence the very justification for you to go on and then discuss the potential liability of parent. In terms of checking off headline points within that discussion, you mentioned I would expect to see preliminary reference to section 1 of the law. Company is a legal person separate from its members, and that's as true within groups as it is within a standalone company. So company is a legal person separate from its members. Whether or not you kind of further that discussion very briefly by setting out how that represents the principle in Solomon, there'd probably be a mark for recognizing that that is the seminal decision in company law. And section 1 of the Guernsey law gives back to that. What does that mean, though? It's a legal person separate from its members. You can't, no. Any claims would be against the legal person, against the company. But what is the extent of their liability? For So again, there'd be a mark or so for mentioning that the practical the practical application of the principle of limited liability. Again, it's always an interesting one to note when people are discussing the interrelationship between separate legal personality and limited liability, because on a number of occasions I've had pretty heavyweight Jersey partners who haven't clearly delineated the fact that Yeah, it's just part of the kind of background justification for why you're going through this discussion. It's only a couple of marks, Jasmine, here and there, and you're not going to, omitting that discussion isn't going to by any means mean you're likely to fail if all you then go on and do is everything else. It's just a couple of marks here, a couple of marks there. That's all it is. But also, hence the purpose of these sessions is that's part of the.
I just jumped in, okay, Solomon, and actually it's not Solomon.
We don't care about the reality.
Yeah, exactly.
Because the fact is, there may be a potential, potentially, what if parent isn't fully paid up?
Yeah, exactly.
You obtain a judgment against subsidiary, parent isn't fully paid up. Well, yeah, there will be money to go into the pot, maybe a very small amount of money, but nevertheless, there'll be money to pay into the pot from parent. It is just such a preliminary point, but it just goes into this discussion more so to justify why you're then suddenly talking about this very academic principle of, can we pierce the veil? Just going to build on your discussion of that. And so in practice, you wouldn't sit down and have this conversation with your client, but this is a good example of how these assessments they're intended to be a little more academic, and these are some of the points that go to that. So section 1, company's legal person separate from its members. What does that mean? It doesn't mean they automatically have limited liability. We see that comes in part under section 6 of section 2. The company limited by shares, the liability of a shareholder is limited to the amount, if any, unpaid on his or her shares. So that, and maybe you've got some short, flowery explanation of, well, that creates the veil between here, our parent, and our subsidiary, because there's a fairly clear-cut claim, potentially, against subsidiary. But as you said, subsidiary is insolvent, so let's see if there's some alternatives. I marked the Atlas case, for example, which talks about what piercing the veil is. If someone put that in and explained piercing the veil is all about treating the liabilities of members as, liabilities of the company as being the same as liabilities of the members, as opposed to lifting the veil, which is for some interpretive reason. Yeah, again, I'll probably say, do you know what? It's worth a mark. It's furthering that discussion. But you're quite right, because the real focus then comes on to, and I think you'd probably mention it, it comes on to Adams and Cape here in the context of a group of companies. Obviously, we have no interest in discussing the facts unless they're relevant to the scenario. House of Lords and Adams and Cape finds that there are 3 circumstances in which the veil may be pierced. And you may give very brief reference to agency and interpretation, which they, 2 of the heads. It's that third, the mere facade, which is never actually really defined in law as to in what circumstances you'll find the mere facade. Bearing in mind that there's no real extension of what a mere facade is in the case law. Based on those facts, if and forgetting the later case law that we'll come on to in a moment, just working on the principle of the mere facade, would that be satisfied, do you think, on the information that you're given? Yeah, because what do you think a mere facade is?
Fraud. Everything going through with parent and whatever parent.
Yeah. What if the company which is being challenged as a mere facade is actively trading? It's carrying on business in the usual way. I think like to kind of being able to shoehorn it into that these are all the difficulties the courts have had with that term, I see.
I'm saying that the subsidiaries of the facade of the parent company.
So if the subsidiary is a facade, a mere facade, you can pierce the veil to look through and hold the company,
Yeah.
the parent account. Whereas that fraud, that's too high. That's going too extreme in terms of what you need to, the standard that the courts would apply. I think you're looking for, if that's what you mean, fraud in its criminal sense. They weren't looking for that. It wasn't necessarily the case that the subsidiary was carrying on some fraud. Simply, I think, as Rachel said, it's just a nothing. It's just a shell, perhaps, that money is going through, and so on and so forth. There doesn't necessarily need to be some fraud carrying.
What case?
Adams and Cape.
Oh, Adams and Cape, yeah.
Mm.
But I mean, isn't that? That's the.
Well,
That's the.
hence I said, ignoring the current case, the later case law, just looking at that, just out of interest, the mere facade, what is it? Well, we don't really know, because the court's never developed a true exception on those grounds. But Press didn't explicitly say Adams and Cape was bad law. Rather, Press focused on the circumstances in which, the extremely limited circumstances in which the courts, it said, had or could find the ability to pierce the veils. But nevertheless, the court was generally of the view it was no more than a mere fiction. I mean, I mentioned DHN. You said it's the single economic entity argument, but that is bad law. DHN was rejected by the court in Adams, so I tend probably not to mention that for the purposes of answering this question. Rather, you're going to Preston Petrodel, and maybe the commentary from the Antonio Gramansky case, which is on here somewhere. In Press, the Supreme Court were very clear, they were very firm. They didn't hold back in demonstrating their, I'm not sure what's the word, their disdain for the idea of piercing the veil. They said it would be possible where a party is under an existing legal obligation, so an existing legal obligation, which they seek to deliberately evade. So under an existing legal obligation, which they seek to deliberately evade through the interposition of a company under the wrongdoer's control. That was the one limited scenario the court felt impressed that it may be possible to pierce the veil. So parties under an existing legal obligation, which they seek to deliberately evade or frustrate by interposing a company under their control. But what was key, and there's a lot of academic commentary on that, but what's key on that is the existing legal obligation. They need to be subject to the obligation before they interpose, are mere facade, they interpose the company here. It would be saying the parent were already exposed to a liability when they interposed the subsidiary to try and avoid that liability. And it's the circumstances, the situations in which that would occur are just, it's incredibly difficult to imagine. The one example, and although the court said again this wasn't piercing the veil, it was just contractual enforcement. The one kind of example that might fit within that would be Jones and Lippman. which is where, if you remember, Lippmann agrees to sell land to Jones. Prior to completion of the sale of the transaction, he sells or he transfers the land into a company. So you see, existing legal obligation, he interposes a company by placing it between him and Jones. Based on Preston Petrodal, you could pierce the veil. That's what they're, in theory. Albeit, again, in that case, it was just a matter of contractual, it was the enforcement of his existing contractual obligations, that there was no need. Hence why Antonio Gramsci, bringing those threads together, the court says there's no further development. This principle won't go any further. And that's Court of Appeal saying that's it. So it's pretty much dead in the water. But nevertheless, for the purposes of an assessment, following that thought process through, to ultimately come on to what you said, which is the imposition of tortious liability on parents, which of course is something entirely outside the realms of corporate law, in effect, in its truest sense, because here we're just applying principles of negligence. And you're right then, I think, in what you said, Chandra, it was very fact specific. It was clear that ParentCo had was fully aware of the issues in the subsidiary. It was fully capable of dealing with those issues. It had the knowledge, it had the expertise, and it didn't do anything. That was where the tortious liability arose. The later cases of Thompson recognised the fact that that just won't be true for the majority of parent companies. The UK structuring is typically, with Topco, is just the holding company. It doesn't have active, it's not carrying on business in an active sense in the same way as its various subsidiaries are. So those are the kind of headline points to draw out there for something on John's facts. What about vulture finance?
It's the same instruction today.
Oh yeah, so all of that's true for that, isn't it? Yeah.
I don't know if this is we should start with R. Skip.
Mm-hmm.
And then just mark up
And B. Yeah, yeah.
For at least
I think so. There's no need to repeat it all.
yeah. Maybe I think we might not have touched on. There might be cases that we haven't specifically touched on in our discussion so far to do with, like Solomon, for example, to do with like loans made to a company and not and so on, like financial arrangements.
I mean, I'm with the fraudulent trading, given that there's an intent to be called the
Yeah.
tax being imposed, and that's where I went with it. Almost exclusively.
Yeah,
But I didn't see any. I mean, I couldn't see anything else that I could talk about there.
Well, yeah, I mean, I just went straight from negligent mistake, but I think I'm just kind of led by the kind of context.
Yeah, you're both right. Ultimately, I think.
Let's do it together.
So, starting point, which there's no reason why you would have picked up on this off the top of your head. VTB was one of the cases I mentioned. And in VTB, which again went to the Supreme Court, the court took it upon themselves to look into the piercing the veil. And one of the comments they made, which is applicable here, is that the court has no power to make the controller of a company liable on a contract to which the company is party, but the controller is not. So the court has no power to make a controller liable on a contract to which the company is party, but which the controller himself is not. Which is just a straightforward contractual point. Yeah, that's nothing particularly new. It's just they mention that Supreme Court in the context of these types of transaction. So no power to make a controller of a company liable on a contract to which the company is party, but which the controller is not. Insofar as, and it doesn't really matter, I don't think, which way around you look at it, fraudulent trading is concerned. What are the elements we need to tick off?
Needs to be one.
Yeah. And who can be liable for fraudulent trading? Practically anyone. Yeah. So the only limiting factor there is whether or not, as Ollie said, you would meet what is a high threshold. Proving intent to defraud is difficult. All you're told here is parent persuaded Vulture Finance to make the loan. Parent told Vulture Finance that GluSub was about to win a substantial new order, although parent knew this was unlikely. Again, some purpose goes into the choice of wording, which is it may not meet what is a high threshold for fraud. But you're right, that is a discussion to be had.
And my understanding is that if that was successful, they'd be liable to contribute.
Mm-hmm.
And that would go to the general pot, wouldn't it? It wouldn't be specifically.
Yeah. So it would go into the insolvency, so parent would contribute to the assets of the subsidiary in liquidation. So it would go into the pot. From Vulture Finance's point of view, though, if that was a course of action which, and remember they can't do this themselves, it's a power of the liquidator to apply, they would have to persuade the liquidator to take those proceedings. In the UK, that would often mean they have to agree to underwrite the cost of those proceedings. There may nevertheless still, it's still potentially worth doing if the prospects of success are there, and on these facts, you can't say. But Laurent is right as well insofar as negligent misstatement is concerned, because here you've still got representations being made to by one party to another. And as you've said, there are examples from the case law where the courts have been willing to apply those principles in this type of relationship. It's not any kind of exception. It doesn't cut through Solomon in any way. It is simply the application of general tortious principles in the usual way. Someone made a statement, negligent in making that statement, but in Williams, what did they have to prove? What was the
reliance on the firm?
There's got to be a reliance, yeah.
Based on
It was a higher bar than that. It was the assumption, yeah, assumption of personal responsibility to create a special relationship, which in that case wasn't proven. Because director shareholder had contributed to the production of this brochure that set out earnings, all of which were misstated, but never actually had a relationship with claimant. That was all dealt with through a manager. And the court wasn't willing to make a finding of negligent misstatement because you just didn't have that direct relationship. And in fact, It's more than just a direct relationship, making a statement by one to the other. It's this assumption of a personal responsibility for building in a special relationship. I mean, in Williams, the court pretty much negated the use of that principle in trying to form it.
Yeah.
They've done so to such a high level. It's almost inoperative in reality. Apart from in my one case where I thought it was probably a slam dunk. But that's pretty much it insofar as vulture finance is concerned.
Should have taken security.
Should have taken security. Well, do you know what, Jasmine? Wouldn't that be an interesting way of extending the question? So as to make it more Guernsey-centric. Those are, as I said from the outset, the purpose of going through those is more to give you examples of how I draft questions, how I produce something a little more factual than those which exist on the Guernsey past papers, and so you can expect to be presented with something more similar to those for the purposes of your assessment. Save that, as I mentioned earlier, I have had to hold myself back a little bit so as to ensure you've got a paper which is actually realistic to sit and answer in 3 hours. And so I've tried to create a balance, half and half across the paper, between something more involved and something less involved. Again, to be sympathetic to the fact that there's an awful lot of content in the syllabus, an awful lot to learn, and not only have you got to sit down and work through that in the exam, but you've got to identify what the issues are. So be prepared for that. Insofar as the topics are concerned, I've said to you, look, roughly syllabus is 50-50 between the company law and the other topics. And of those other topics, I think you'll probably agree with me that the most interesting are security, foundations, partnerships, and everyone loves licensing. I can't seem to get away from licensing. Those are probably the most exciting topics, aren't they? I would have thought. I was passing comment on them. Obviously, those questions we've taken out of the Jersey paper don't cut across anything other than the company law issues, and hence why I'm making this point, because Jasmine helpfully raised it for me, which is these sets of facts in themselves have a core company focus, but there's no reason why, in parent and glue sub, that couldn't be extended so as to bring issues, to bring in issues of security, for example. I haven't done a legal personality question with security, and I'm just taking it as an example, okay, of how you could also build that into the facts. And I think it's probably, again, realistic for you to expect that's a pretty necessary approach to have to take, because the issues going to security, it's hard to build up a 25-mark question unless, as we saw in the Guernsey paper last night, you go through 5 different forms of security and ask you how to take security. I don't want to do that. I'm not interested in doing that. To me, it's preferable to have your set of facts, maybe to have some issues from the company law, but also to bolt on some issues going to a particular form of security, one or two, just to extend the question further. And with that still being phrased as a 25-mark question, it's no different to what I've said throughout today. 15-ish marks is just going to be testing your knowledge or understanding of the law. 10 marks or so a more subjective assessment of the advice that you give. And whether that's a build-up of company issues or security issues or foundation issues or licensing issues, it doesn't matter. That's what I've tried to do is to find that balance between the various topics. So, as I said, certainly security, licensing, foundations, partnership, those are all hugely exciting topics that I like. As far as a company law is concerned, there's vast swathes of it, but, you know, headline point is you need to know it all. But I've already indicated to you, there are topics within there which much better lend themselves to problem questions and the nature of this assessment. It's easy to draw out issues from corporate capacity. We've looked at that today, which I think is limited to 4 slides or 5 slides or something, looking at issues with objects, looking at issues with articles, etc., and transactions with third parties. The constitution of the company, well, as a topic within the syllabus, that brings in some quite academic type points that aren't hugely interesting from an assessment point of view. But remember, within constitution of the company, you've got alterations. And that's always a good flashpoint for fallout between shareholders. So within constitution of the company, alteration of the articles, that's a good one. Directors' duties, of course, hugely important. We've come across that a couple of times so far today. And again, it's something you need to have a good grasp of. It's not only looking at Carlisle and the formulation of the duties, but remember they set out what the standard is that's expected, those other slightly random factors to which the court will have regard, and some of the core English case law that supports the interpretation of those duties. Now, the discussion, the study guide is lengthier than it probably needs to be in terms of what English case law would you draw in to a discussion of directors' duties. And so probably if you were guided by what's on the slide, on the PowerPoint slides, that deals with the headline English jurisprudence where necessary. And so directors' duty is hugely important. And if you take any of those kind of headline issues, corporate capacity, constitution of the company, directors' duties, all of those can then feed into, well, what next? What is the cause of action here? And I said earlier, there you're looking to who you're advising, because who you're advising is going to dictate what the available causes of action are. Liquidator, we're looking at misfeasance, we're looking at fraudulent trading, we're looking at wrongful trading. I'll come back to liquidator in a moment. For the shareholder, you're looking to derivative claims, you're looking to unfair prejudice, you're looking to J&E winds up. Those are the causes of action that you're going to need to be comfortable dealing with. They may not all be relevant on the facts, but could be. Something that I don't think we covered off, did we, in the TOR classes, I can't remember, but which is fairly straightforward to run through. The powers of the liquidator in insolvency, which go beyond those headline causes of action. So misfeasance, wrongful trading, fraudulent trading, fine. But remember, the liquidator has wide-ranging powers. They can look back over varying periods of time, and they can undo certain transactions, or more likely, they can hold directors to account for preferences, transactions of an undervalue, etc. So you need to have a grasp over those wider powers of the liquidator. those then are all areas of the law that go to litigation type issues and the types of problem question that we've been looking at today, where you're advising someone how to seek a remedy. A simpler set of facts, more in keeping with Mr. Ned, for example, would be asking you to advise from a more transactional point of view on certain issues. And that discussion needs to be kept within an area of law that's got quite a narrow remit, and which again levels the playing field and is accessible not just to the transactional lawyers but to litigators, and also needs to be somewhat Guernsey-centric. So what can we draw out from the law that is Guernsey-centric? Well, things like PCCs, ICCs. It isn't exciting particularly, or it doesn't excite me, but you can do things with them. You can convert them. You can amalgamate them. You can migrate them. You can do interesting things. Not really, they're not interesting, but you can do things with those structures. And that's all very, it's more Guernsey focused than other areas of the law. So certainly PCCs, ICCs, I would get a grip on those and the kind of things that you can do with them. Now, you'd look in the study guide, you'd see conversions, you'd see amalgamations, and you'd think there are pages and pages dealing with those processes. But there's no case law, really. There are a couple of cases, I think, on amalgamations, but there's no real body of jurisprudence because they are procedural. And as much as I've said I'm not keen on those questions that just take you through procedure, the years and years worth of Guernsey past papers do that. And as I said, I've been reined in slightly in my approach to these questions. So don't be surprised if you are tested on those more procedural type points. I'm not sure there's much more I can say about security, licensing, etc. We've discussed it ad nauseam. They are what they are. You're not going to be tested in an incredibly technical way as to some obscure way of dealing with a particular form of security. If you're assessed on it, it's going to be the headline, procedure, and the security and press law, because that's what it is. And to level the playing field, that's got to be the nature of the assessment. So you ought be able to, I think, cover that off in your revision pretty easily. So you've got obviously the security interest law. Bearing in mind that when we looked back at one of the questions yesterday, that included not only the process of taking security, but also the formalities that go to security agreements. Don't lose sight of that, even if it's not, your attention is not specifically drawn to it. There are formalities that go to that. And obviously there are forms of security that don't exist within the security interest law. But the extent to which there can be any assessment of those needs to be, again, pretty limited. As to licensing, again, the issues would have to be, well, along the lines of perhaps if X wants to do Y, what are the licensing requirements? How do they satisfy those requirements? That goes in line with some of the Guernsey past papers. If you're bringing it closer to the nature of the assessments that I'm used to drafting, then you'd start to be looking at, well, what if they breach the terms of their license? What if they're subject to a condition and have they or haven't they breached that condition? What if they don't have a license? It's those kind of issues on which you can see there'd be a more substantive advice to draw in. As to partnerships, well, you've got partnerships, you've got LPs, you've got LLPs, and assessing the knowledge of those doesn't need to be any different really as to the way in which we've seen these problem questions on the company's law. What if a partner exceeds their power? In what circumstances will a partner be liable for the debts, liabilities of the partnership? What's the difference across the different forms of partnership? You know, we saw that example earlier, didn't we? But what if the limited partner wants to take a role in management? All of those issues are relatively straightforward. And of course, all helpfully answerable by reference to the relevant law for each type of partnership. Again, it's no different for foundations. You've got, for example, officers who owe certain duties, certain obligations, who can be exposed to liabilities in certain situations. And so simply across those various types of vehicle, I think you could expect an assessment to take one of two forms. It would either be, well, what is the appropriate vehicle for this set of facts? In which case you're just looking to what the client wants to achieve, and you wouldn't be expected to have any detailed transactional knowledge. It would just be looking at headline functions of the different forms of vehicle and the protections that are built into them. The example we saw in the other past paper was as to transparency, wasn't it? They wanted to disclose as little information as they could. So either suitability of vehicle or something more akin to what we've been looking at today, which is some fallout within whatever the structure is, whether it's a partnership, a limited partnership, LLP, foundation, some fallout, something's gone wrong, and a set of facts, you know, similar to what we've been discussing today, but within the context of one of those alternative vehicles, who's exposed to a liability? That's probably the end game. Things like reporting requirements and, I don't know, the role of the company secretary, stuff like that. It's just, you know, it's in the syllabus, but kind of incorporated into a problem question. Reality, assess on things like that. So don't be, I don't know what you think from all of that, but perhaps reflect on my comments and begin perhaps to give some thought as to the kind of issues that are likely to crop up based on everything I've said in the last kind of 10 minutes or so. I thought when I wrote this out, I thought, well, that looks like quite a firm steer, but then I remembered that actually, if you look at this in the study guide, that still makes up about 300 pages or so. It doesn't really. It's still a couple of hundred pages. Yeah. Any other questions then? Any other pressing concerns? It is too late to back out now. I'm afraid you're committed.
You're right. Yeah. My people once said that, but the GTN. Yeah. I think that's yeah.
It's not going to be, it's just.
I said I'm doing it on computers.
Ah, yeah. Well, that's positive. Everything will be typed.
Yeah, well.
Not me. You're not afraid. You will.
Can you take a secretary and dictate?
I don't actually know. Yeah.
This is the modern world, isn't it? We don't have secretaries. If I was secretary, I have a personal assistant, which I think meant we didn't have to give her a pay rise one year because she was getting a new title and stuff.
And it's non-gender specific.
No. So we didn't have to give her a pay rise.
Yeah.
You promoted. You're a PA. So no pressing questions, because I did leave time for pressing questions. Only 10 minutes, please. Yeah. You need to sit down, you need to reflect, and then if there's any issues, you need to drop me an email.
I think it's crystal clear as always.
I don't know if you're being disingenuous or
No,
not.
you know, you think it's as clear as mud, thank you very much, but actually, no. Didn't.
Well, like I said, in that case, any questions, by all means, drop me an email, and I will endeavour to answer if I can, and I'll pass it on to an adjunct. But what I would be minded to do, unless you said otherwise, was to disseminate it to everybody so that you'll benefit of the question and the answer. Similarly, as Laurence said earlier, if you want to, if you have time, you've got here on the back of this September 2017, and there's question 3 about algorithms and CPAC PLC, but ignore that it's a PLC. And if you want to have a crack at doing a page, half a page, or 4 pages, or bullet points, or whatever, by all means do so. And let me have a quick skim back through and give you my initial gut feelings on how well you would have panned out on that.
I mean, just from an experience point of view, in 45 minutes, how much do you physically get through in kind of structure that we've gone through in that time? You usually see the time.
And is it full price or is it bullet points?
It varies. I always say, look, it doesn't hugely bother me if it's not a beautiful flowing narrative. Fine, you're pushed for time, the better you can do, obviously the better it comes across, because overall we're reflecting, as I said, quite subjectively on the chalk of the marks.
Yeah.
But if you start to run out of time and all you do is chuck down a load of bullets, as long as I can understand what they say and I can understand what the intention was, then you'll certainly be getting your marks for your kind of knowledge and understanding, because you're saying section 445, section 2. Brilliant, fine, happy with that. What you might, what bullet points probably won't achieve is the same level of advisory, kind of explanatory analysis that you would get from your narrative. But as long as you're ticking off the marks, get over that threshold. But in answer to your question, what I see most often is 2 very well written answers, a third which is not so good, and then a 4th, because I always say make sure you answer all of the questions, a 4th which is a quarter of a page. That's what I see most often, to be honest with you. But bear in mind again what I said, I've tried to balance between 2 longer questions and 2 shorter, simpler, more straightforward ones. But yeah, go in prepared knowing that you're going to have a set of facts and you've got to distill from that information what the issues are and what you need to advise. But there, you should be able to identify the headline points, going to someone's experience, going to the solvency of a company. That's what those are designed to be. Ideally, you would have another 8 hours to go through seminars, wouldn't you? On an undergraduate degree, you would do the law, and then you'd have the seminars. That's the technique you'd be learning, but you don't have the benefit of that because you're practitioners. So the assumption is, set of facts, these are the issues, away we go. But it's difficult in exam conditions. Like I said, I wouldn't want to do it. I have no desire whatsoever.
We just need to break it down a bit more and we'll be in practice.
Yeah.
Back section one.
Exactly.
Absolutely.
That's what we found.
Absolutely.
It's like the overriding objective.
Okay.
But surely in civilisation you do.
Yeah,
Surely you would.
yeah, but I mean, yeah.
That's fundamental, isn't
Yeah,
it?
yeah, but it's like we kind of, it's like fundamental.
Yeah, yeah.
We forget to talk.
That's what I say. The number of times I say overriding objective, I think I bore myself. I phone people all the time and say, do you know you're acting in the interest of you?
It has no application place or relevance to what you're saying. Okay, just stick it in there.
It's because I'm going around threatening adverse costs all the time. Objective. Fine. All right. Well, we can leave it there. We've served our time for today. And works that well. We can head off. So M&S.